The United States Supreme Court justice needs a moral authority. It needs a conscience. And Sonia Sotomayor, Associate Justice, has stepped forward once again to be that moral clarion call for law and order, a rule of law, and the importance of the independence of the judiciary. She does it in various ways. Recently, during an interview, I mean, we don't normally get kind of interviews during the term, and we are in the middle or towards the end of this particular Supreme Court term. It started in October, it ends around April. She did, in an interview, have this to say about threats against the independence of the judiciary and the importance of an independent judiciary for all concerned, whether your name is Trump or not. Let's roll the clip.
More than ever, we have to get up and explain and repeat and explain again why judicial independence is critical to everyone's freedom. Because arbitrary power is just that. And it means that anyone is going to be subject to unfairness at someone else's whim.
Now, I use that as a springboard to talk about a more recent decision by Sotomayor. I was scrolling through, as you know, as a Supreme Court nerd that I am, in preparing for our unprecedented show here on Legal AF, the list, the order list, which is usually just one line of the court controlling its own docket, the Supreme Court, and saying, denied, the motion is granted, the motion is denied, the order is dismissed. You know, just very simple things that they don't do with one of those longer opinions that we talk and labor over so much from the Supreme Court. It's a way they control their docket. And sort of buried in the list, I'll show you what the list looks like. All of a sudden, I see a major dissent from Sonia Sotomayor right on the heels of her comment there. And what it had to do is, it has to do with criminal justice, but it goes beyond that. It's in a case called Shockley. And in Shockley, Lance Shockley, was convicted in a drunk driving accident of a vehicular homicide, murder, that type of thing. And he had an appeal that he wanted to take, or a writ, what's called a writ of habeas corpus. In order to get a writ of habeas corpus, you need to go through a judge. A judge has to approve it and give you a certificate of appealability. And different circuits around the country treat the certificate of appealability issue differently. That really shouldn't be. The justice that's meted out in Oklahoma should be the same type of justice, at least procedurally, as is meted out in New York, New Jersey, or California. But that's not the case. In some circuits said that if one judge on an appellate panel of the three judges finds that there should be the certificate of appealability should be issued, that's enough, even if the two other judges say no, because it's enough to get it before a jury on the issue of whether this person should be taken out of prison and have a stay in court. And there's enough circuit splits, and Sotomayor outlined them, 5 or 6 or 7 of them, all different. And she said now was the time for the Supreme Court to step forward and give clear and proper instructions so that the criminal justice system falls the same on all people, regardless of where they live. Shockley, I think, came out of the 11th Circuit, which would have covered, like Georgia and Florida and the like. And so she goes through in her dissent and talks about the main issue in the case, which was apparently a juror, and became the jury foreperson, said during the questioning period at the beginning of that trial, what we call voir dire. He said, I wrote and self-published a book, and nobody followed up on it. Turned out the book that he self-published was a semi-autobiographical book about a vehicular homicide and a drunk driving accident. Sounds like somebody you at least want to ask more questions about to get to the bottom of whether they were fair and impartial, or they were trying to write a proper, an interesting ending for the book that they wrote. But that got passed. That's the merits. And what the judge is upset about, and understandably so, is that the Supreme Court passed on the opportunity to clarify the various rules that are different in the different states and in the different jurisdictions about this certificate of appealability. But it goes much further than that. It goes back to what we just talked about with fair and impartial judges being properly instructed in order to regulate and administer our body of law and our rule of law. Now, Donald Trump doesn't like to talk about the Article 3. He doesn't like to talk about Article 1. All you ever hear him talk about is Article 2 powers of the president can't be challenged. And that's not true. We all know, and we knew from grade school, when we were all wearing short pants, that the three co-equal branches of government check and balance each other. That friction that's created among those circles that are spinning create the check and balance that our framers wanted. It is the role of the Article 3 judge to step forward and call foul when the executive branch has gone too far, violated its war powers, violated its constitutional powers, its absolute core constitutional function, however you characterize it. That is the role of the Article 3 judges up to the United States Supreme Court. Process is the same, even though it seems to beguile the Trump administration and all of its spokespeople. A single federal judge and a single federal circuit or district makes a ruling, thumbs up or thumbs down, about constitutionality, or just to give a quick primer of what's been going on in all these 150 lawsuits against Donald Trump, they basically fall into similar categories. That the arguments are that Donald Trump, one way or the other, through executive action, executive orders, violated the Administrative Procedures Act, or one of his agencies did, which requires that actions not be taken arbitrarily and capriciously. That's a term of art under that body of law. So Administrative Procedures Act violation, First Amendment violation if it's targeting some viewpoint of the party on the other side. Donald Trump doesn't like the lawyers, doesn't like who they represent, doesn't like the protesters, doesn't like what they say, doesn't like the not-for-profits, doesn't like what they, the type of activities they engage in, doesn't like DEI, diversity, equity, inclusion. Those are all First Amendment arguments. Then if you don't have that, if you're going through your checklist as a plaintiff against Donald Trump, a successful plaintiff, you then go into the constitutional other violations like equal protection under the law under the 14th Amendment. Is Donald Trump's policy prejudiced or biased against you because of your racial group, your sexual orientation, your no sexual orientation, you're a transgender person, you're a Venezuelan person, you're a woman, whatever it is? If that's the case, you probably have an equal protection 14th Amendment violation, right? Perhaps Donald Trump, by his actions, is also, could be and or, taking away a right that you have, a license to do something, a permission to do something, some sort of property right. The Associated Press being able to participate in press conferences, right? Law firms being able to represent people before the government, lawyers too. Your ability to conduct business in a certain way, which is given to you by license. And so what happens? What happens is Donald Trump tries to take it away. You have a Fifth Amendment due process potential violation because you're able to argue that your property rights are being denied you without due process of law. That would apply to people like the Venezuelans and purported members of that narco-terrorist gang who are not being given any due process to prove they're not a part of the narco-terrorism gang. They're a hairstylist. They love soccer. They're a woman that's not a member, or things like that. That's the way these lawsuits are breaking out. And what Sotomayor is saying there in the beginning is that there is a role, an important role in our constitutional order for Article 3 judges. And they need their independence in order to do their job. And what she's worried about is the same thing that Chief Justice Roberts was worried about on his January 1st address at the beginning of this year, when he said the number one thing he was concerned about in his State of the Courts address, which he does every year, this year was judicial independence and the attack on the judiciary by Trump, people that support Trump, politicians, and that the fear is this pressure campaign, this weaponizing attack on judges, their staff, prosecutors, their staff, firing Department of Justice, has a chilling effect that we may not even ever get to the bottom of, where these people just should boldly act, but decide to not act at all. Pull the oars in even if it's just a little bit, right? If before the attacks, because they don't want to be attacked, they don't want to have violent threats against them, they don't want to be doxxed, and they become more timid. We don't want a society of a timid federal judiciary up against a bully in the presidency. That just creates a wet noodle here, a wet noodle in Congress, and an out-of-control presidency. That's what Donald Trump wants. The more he can get people to be timid around him, the more he can accomplish in the short amount of time that he has. Forget about the third term thing. Trust me. We will send in the National Guard to take him out. You saw the movie Civil War? Hold that thought. Now, on the timidness, what I mean by that is, if the judge is bold and independent, they may have, before Trump, they may have made a decision that was out here. But because of Trump, they make a decision that's here. And in that gap, where they should have been, but where they are, that interstitial gap, that's a loss of freedom. That's a loss of our rights being protected. So it's not just Popok's describing how big a fish he caught. It's not a fishtail. Well, I caught a bass. It was this big. It was this big. It was this big. Off the screen big. This is talking about where on the spectrum our rights are allocated and protected by the federal judiciary. That's what Sotomayor is concerned about. So I wanted to kind of bring it all together in one hot take for you about this moral clarity of thought by Sotomayor, joined oftentimes by Kagan and Ketanji Brown Jackson, because of its importance. I'll continue to follow it all right here on Legal AF. You're here already. Help us continue to grow this pro-democracy channel in collaboration with the Midas Touch Network. Hit the free subscribe button, then follow me in a couple of places. Popok Live, a new podcast on Tuesday nights, 8 p.m. Eastern Time on the Midas Touch Network. And then on Legal AF, the OG podcast, top 10 in the world, at the intersection of law and politics, Wednesdays and Saturdays at 8 p.m. Eastern Time, also on the Midas Touch YouTube channel. And then you can pick us up on audio podcast platforms of your choice. So until my next report, I'm Michael Popok. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.